Very warm welcome to Stewarts Soundbites back again for another week. We're on episode 15, believe it or not. So we're joined today. I'm absolutely delighted that I've managed to convince Gerard to come back to do a second session, back by popular demand. We have a really interesting topic today. Gerard's going to be speaking to us about key issues arising in care claims in catastrophic injury cases. As ever, it'll be interesting and really hope you enjoy it. We don't have much of a structure really, Gerard, because you're a pro and you have so much experience in this area that I'm just going to hand over to you, and I'll just interject the odd time with a question, if that's all right.
Well, that's kind of you, Emma, and I'm delighted to do this. I've done catastrophic injury work for probably 30 years, I suppose, now. And I suppose I realised quite early on how important care was. Because I'm married to a nurse, I suppose I used to pick her brains quite a lot. I picked her brains so much that she asked what these care experts were all about. And as some of you will know, she became one. I suppose also talking to her, but working with the cases and working with the experts and the families, crucially, and the individuals who are the subject of the awful injuries that we have to deal with. I suppose I've learned quite a lot about care. We know it's important. I'm going to talk a little bit about how care can be delivered, how it should be measured, why there's such a difference sometimes, and when you might justify nursing oversight or nursing care. I've set myself a bit of a task because I can see we're at 3 minutes past 1 already. From a legal angle, from a lawyer's angle, how do I view care? And it's not just a lawyer's angle. You can't do these cases if you're just a lawyer. You can't do them if you don't have empathy and interest in the individual who needs the help. I would say it's key to restoring a person as close to their previous life as you can. It's not something we can ever really achieve, but we can make life easier. It's not about just the care that may be essential to having an existence. And I confess, I sometimes think that some of the reports I see are not a great deal more than that. It's about enabling people. It's about enabling them to do what they want, when they want. The late Brian Gardner, who has been gone from us for more than a year now, used to say it's about people enabling someone to do what they want, when they want, in the way they want. And that's from a rehabilitation expert. It may sometimes be about prompting. It may be about keeping safe if they have a brain injury that's affected their perception of danger or the ability to have a structure. It can sometimes be about accessing the community with a buddy, about whether it's overcoming fear or overcoming the obstacles in everyday life, which for many people may be unevenness in the pavement or the roads and difficulty in getting to sports stadiums and so on. It may be about providing structure, particularly in the case of someone with a serious brain injury. And I suppose I've learned a lot of that. I've learned a lot about that from people like Neil Brooks and Kathy Johnson and Maggie Sargent and many of the other people that we know about. Some experts, I think, really, you've just got to step back and think, what am I being asked to assess here? Is it what someone absolutely needs? Well, no, it's not really. That may be the test that a local authority providing social care may use. It may sometimes be part of the test that a clinical commissioning group may use. The essential test in a personal injury case that's determined under the law of England and Wales is what is reasonably required. It's not about getting the cheapest. And if you have a regime in place and it works and it's reasonable, the court is entitled to adopt that. The fact that it could be done cheaper or in a different way may of course be relevant, but it's not determinative. Equally, of course, we all know that if we have a regime in place that appears to be such that there are periods when really care isn't required, or the rates paid appear to be out of line with the market in the area, then of course we have to take that into account. So is it going to be agency or direct hire? By direct hire, many of those who are watching will know that I mean either the case manager or the deputy or the individual claimant or his or her family employing people directly? Well, my experience is that on someone being discharged from perhaps a spinal cord injury unit or a brain injury rehabilitation unit, if you're trying to set up a regime, you may want to use agency care. It's flexible, it can be more readily available. You're not going to have to worry about training, recruiting, sorting out all the other aspects of a care regime. And also, of course, we know that sometimes the claimant and his or her family may be initially reluctant to accept care in any kind of a case, unless it's absolutely required. And it may be easier to introduce care if you're bringing agency care in. And particularly if you've got different agency carers, some may just not gel with the family and you may need to have a bigger pool. Of course, in some cases and instances of acquired brain injury, particularly, the behavioral issues that sometimes go with a serious structural injury to the brain may be such that even for the best carers, it's sometimes difficult to keep them, and you need to have the ability to rotate them and to bring some others in at short notice. It may be just that the situation is such, the family dynamics or the like, mean that it's just difficult to staff. I think most people probably would go down the direct hire route once they've got an established regime and when they've got a house that's been adapted with the proper space where the carers can retreat to and so on. In fact, agency care may not often be much more expensive than people think. By the time you've added on the on-costs of dealing with direct hire, at what, 32 to 34%, something of that kind, it may be that it's not such a difference between the agency care. Sometimes I come across defendants, counsel and solicitors who say, well, the agency is making a profit. And I'm saying, well, how did you expect them to exist if they didn't? But of course, my experience is that you get what you pay for. And in some cases, the quality of care that you need may be such that you have to pay just more. And as a lawyer, as a claimant lawyer, you need to be producing evidence to show that it's required. What about live-in care? A lot of people think live-in care may be the answer, where there's an ad hoc requirement for care from time to time. And of course, it's a part of the fabric of the care sector. Outside the question of compensation, many people will have live-in carers as they get older and just can't manage. I want to say something about live-in care. The working time regulations and the European cases that underpin the inability to do sleep-in care and daycare in the same 24-hour period remain the law. They're underpinned by UK cases. They're underpinned by the regulations. They're underpinned by the European law that the courts in England and Wales can still refer to after the 1st of January 2021. There's a maximum 48 hours. You can opt out of a maximum 48 hours. I know, and I do it in every seminar or webinar that I do on this, that many people think that if you can do a 3-hour break in the day, it's okay. Or they'll say, well, this agency says they can do it lawfully. It's really simple. You can't. If you are on duty at night, then you will be working. The one case in which I've always felt you perhaps could do it is that if you have someone in as a sleeping carer against the event that there is a fire or the like that the individual can't deal with, and that they have an expectation of being not disturbed, then it may fit. And I also understand that sometimes it's more convenient to deal with living care in terms of recruitment and so on, as long as they're not disturbed at night. I know it's honoured in the breach, but it's still the law. And really don't let anyone else tell you that's the case. If it changes, I'll flag it up with another webinar.
And good.
I said I was going to,
I'm going to hold you to it.
Well, I know that. I said I was going to talk about Mencap and Tomlinson Blake, which is a matter that came before the Supreme Court in February this year. The decision isn't out yet. It may be out, should be out early next year. So I haven't got a great deal to say on that. It's about the minimum wage for people who sleep in overnight.
We'll add that to your list of upcoming soundbites.
Okay. Now, before I go on to just 2 minutes on when you can put nursing care, in my view, as a lawyer, in terms of justifying it to a court in, I know we had a question before, and I'm going to put the question out. How might care experts approach the future care costs if it's unclear whether the claimant will actually use a commercial service, considering the actual cost of a commercial package will be much more, substantially more than the package based on NJC rates? Well, my answer is that the question a care expert has to ask themselves is, what is reasonably required? There may be a reluctance on the family to use care initially, but the question the court wants to know is what is reasonably required. The fact that someone may be reluctant to accept care is a commonplace. The fact that someone may initially want to depend upon their family member, their spouse, their sibling, or the like, yes, it's relevant perhaps in persuading a court at a particular level. But my test is this: what happens if that person isn't there? What happens if there is a separation or a divorce? Or there is another reason why they simply aren't available? What the claimant's entitled to is what is reasonably required. Sometimes you may want to put some gratuitous care in. I would discourage that. But again, it has to be a question for the care expert. It may be that the family do want to do some, and it may be that there'll be 7 or 14 hours in a full care package that is conveniently dealt with that. But the question I come back to is what is reasonably required. I was going to do 2 minutes on when I think nursing care can be justified. Actually, it can be justified when the expert witnesses say that it's justified in their experience. But when might I look for it? Well, I suppose if there's an issue of oversight or leadership in a complex care package. If I'm acting for a client who perhaps has a tracheostomy, which can be managed at home, as we know, it can be managed with skilled carers, but I think generally I would expect to see, though again, it's the expert evidence that I would rely on, I'd expect to see some nursing oversight in that situation, particularly if they were perhaps in a minimally conscious state or the like. Another example, I think, is where stomas are a problem, where really there's a need for clinical input. We expect a lot from carers that take on these packages, and they are skilled, and many of them are real aptitude, and I don't want to diminish the very good care they often offer. But sometimes the question is there a real clinical expertise that's required in here? Or if there's perhaps polytrauma and things like tissue breakdown and other issues, perhaps mental health issues that really need a skilled input. I mean, actually, nursing care is required when the evidence says it's required. And that would be my approach. Emma, you and I know I could talk for at least half an hour on care, but you asked me to do 15 minutes. I'm happy to take any questions if we've got 60 seconds, if anyone wants to ask a question.
Yeah, for sure, Gerard. We do have a little bit of time, so if anybody wants to pop a question into the Q&A box, then now is the time. Do you have any, I was wondering, Gerard, sometimes it's not that a person necessarily needs a care package, but maybe some sort of buddy, to access the community. What's your experience of claiming for a buddy?
When I first started doing brain injury cases, I saw a lot of people, I suppose, and we still see them, who look to you as though they're doing okay. And then the more you spend time you spend with them, you realize they aren't. And I can think of 1 or 2 cases that were seminal in developing my understanding of it. And actually the neuropsychologist who taught me most about it was Neil Brooks. And I said, well, what are these carers doing? Because that's the question that comes. He said, you've got to ask the question, what would happen if they weren't there? And I said, what would happen if they weren't there? He said, they wouldn't look after themselves. They wouldn't get up in the morning. They wouldn't go out. They wouldn't have a structure to their life. And many of them might end up in institutional care. And I often think of that, and you can see it. And again, I've seen individuals, when I've initially met them, I'm thinking, well, this is going to be challenging to persuade the court what they need. And then as a barrister, as a lawyer, you and I know you've got to look at what the evidence is to show that they are forgetful, that they are perhaps a danger to themselves, that actually it's not safe to let them be alone for more than an hour or two, and you put that in. One case I can think of, 10 years ago, a man with quite a serious brain injury, he seemed to be doing okay, and it was from the Welsh valleys. I remember it with great fondness. I went to see him a couple of times, and he got a friend to work with him 16 hours a week, I think it was. And this friend didn't have particular caring skills, but he was a caring person. And they did things. I mean, actually, the fence at the back of the house was creosoted very regularly. Mm-hmm. And they went to B&Q and they did stuff and they bought stuff. And it gave him a real structure to life, and it gave him a purpose that he wouldn't otherwise have. And I've always thought that's a very telling example of how you can improve someone's life by having a buddy. Minimum amount of time agency will accept for a visit, i.e. needs help morning and evening. Okay, between or school, great variation, might get 2 hours, rare, but usually 3 or 4 hours. I must say, I've always thought, as someone who's done really quite a lot of cases and therefore dealt with quite a lot of clinicians and care experts in particular, it's all right suggesting just a very short period of time in the morning or the evening with someone. It's then a question of staffing it. We know the constraints on social care that mean that people have to dash from appointment to appointment to try and make it work. I think that one has to take account very much of the market. What will people come and do as a minimum? And I think it's always important to keep that at the front of one's mind. It's not just reasonable needs, it's what do you need to do and what do you need to provide for people to come and do the job for you. Do I have time for one more question? I see there's another question.
You do. Go on ahead, Gerard.
Your views on a second carer when only needed for manual handling. And again, I'm guided by the science and the experts, I suppose. I know that there are some manual handling experts who think that done in the right way, there'll very rarely be a need for a second carer. I would want an expert either to have expertise of manual handling assessments, or I would go to someone who did manual handling. I did a case quite a long time ago for a man who needed turning at night. And everyone came up with a turning bed and so on. But when I spoke to the clinicians, they weren't really very good. And they didn't actually turn you properly. I have seen them incorporated into a package as part of the routine, and it may be there are better ones available. But actually, if it needs 2 carers, it needs 2 carers. And of course, there are some cases where it's an absolute need. If you've got someone who's a ventilated tetraplegic, you need to have 2 carers, and one needs to be in line of sight all the time in case anything goes wrong with it. So I think, again, it's the evidence. I'm not trying to be fatuous on the answer. I know that there are techniques which can work, but I also know that sometimes, particularly if someone has spasms or the like, or is perhaps a little obese, that hoisting is not straightforward. So that would be my view. Again, guided by the evidence, but I'm alert to the issue.
It's so interesting talking about all this stuff, and it reminds me as a solicitor as well about the importance of kind of, insofar as it's possible, trialing these different care setups and what might suit a client as far as possible during the litigation process from an evidential point of view, and being able to come back to that person and say, this is what's working, these are the reasons why, and presenting that.
Well, it's good for the judge as well if you can show that it works.
Yeah.
And it's within a range of reasonable costs, the judge is likely to accept it.
Yeah.
If you can show a judge that it hasn't worked because it needs more carers or it needs more skilled carers, it's much easier to persuade a judge that actually you need a better care package. My final thought, actually, I was just thinking was this, that I would just inject. A lot of the cases that we have that we find difficult to settle are because of the care element. I just leave you with this thought. What we don't do here that they do in America in trials is they depose witnesses before the trial. So they cross-examine before trial on a video link. I must say, I've often thought that for many of the catastrophic injury cases I deal with, there would be a lot of merit in this one area, in having not just a joint statement, but having people properly prepared and cross-examine the 2 care experts. It might prove to be nearly as expensive as a trial, but actually you then know where the strengths and weaknesses lie, and there will be strengths and weaknesses in most cases on each side. As ever, I've been delighted to do that with you, Emma.
Oh, thank you very much, Gerard. It's massively appreciated. And it's, as ever, been really, really interesting and it's insightful. So thank you, Gerard, especially this close to Christmas. It's so good of you to give up your time. I'm very grateful. Thank you ever so much, everyone, as always. And if we don't see you before, have a wonderful Christmas. Take care.
And a happy Christmas from me too.
Thanks, Gerard. Bye.